Diddy cannot seem to win on these allegations against him in his criminal case. And today we are going to be updating what has been going on with Diddy's criminal case since we last covered the case back in November of 2024. Yeah, the last time we talked about Diddy criminal case was a year ago. No, it wasn't a year ago, but it was last year. And where we left off with Diddy case is that he was filing a motion in order to, what was he doing actually? The motion was denied. I can't remember exactly what the motion was, but anyways, a bunch of other things have happened since then. Now it is completely blank in my mind what the heck we talked about last time with Diddy. Either way it goes, around the time that we left it, he was trying to get out on bail. That was important. I should have remembered that. That is pretty important. Diddy was trying to get out on bail and he was denied. And while he was denied of bail for the third time, his bail request was also up on appeal. He has since then dropped his appeal for the bail. I guess he's just accepted his fate in that he's just going to stay in jail until all of this is figured out. He did that right after a superseding indictment was filed against him for more criminal complaints under the RICO and all of the same things that he was sued under, or not sued under, indicted over with Cassie, except it adds 3 more victims that we're going to talk about. And yeah, it's just been a lot going on. We got motions to suppress evidence. We got motion to get more, to change the protective order that's already in place. We got Diddy allegedly violating the protective order, but actually not allegedly because the court kind of found in favor of the USA on that. We just got a lot of stuff going on in Diddy case. And now we are not going to cover every single document that has been filed since the last time we covered this case because we left off at like 50 something documents. We are now at 148 documents. So we are definitely not reading everything that is going on in Diddy's case, but we are going to kind of be touching base on what is going on in the case, where are we at, and how is this thing going to proceed? Remember, we're set to go to trial on this thing on May 5th, and he still has to be arraigned for this new superseded indictment and all the other things going on there. So if you are here live, make sure you guys are hitting the like button and dropping your thoughts in the chat. We are going to jump into the chat at the end of the live stream. So let me know what y'all thoughts are on everything that's going on with Diddy's criminal case. If you're on the replay, of course, feel free to drop in the comments how you guys are feeling about the case and what you think is going on. And again, if you haven't already, please do hit the like button. It does help us out on the channel. And if you're not subscribed, please do subscribe because we're trying to grow the channel. All right. So anyways, let's go ahead and have Bossy B bring us into the first segment of what the heck is going on with Diddy. So Bossy B. Okay, y'all. I told y'all it's a lot going on with Diddy. I don't even remember everything that I just told y'all that is going on with Diddy. But let's go ahead and start off with the superseding indictment. For those of you that have been following this case, you know that Diddy was arraigned back in September on allegations of RICO charges of basically having this criminal enterprise and abusing women through that criminal enterprise, and also kind of dealing drugs and dealing with firearms and all kinds of things back in September. We could tell that the allegations were about Cassie because they literally mimicked the civil suit that Cassie filed that Diddy ended up settling on for what we believe to be about $30 million, which she asked him for that originally, and he probably should have just gave it to her. But anyway it goes, she ended up filing the lawsuit. He ended up settling within 24 hours. And then we get this criminal complaint alleging the same things that Cassie alleged in her complaint. And now we got hit with a superseding indictment just recently on January 30th, accusing Sean Combs, of abusing 3 more victims, making them engage in commercial sexual activities against their will. We got one victim is accusing him, or the state is accusing him of dangling one victim over a balcony. I think I know who this is because they also, if I am correct, filed their own civil lawsuit against Diddy that is still pending. I don't want to throw out any names yet because this superseding indictment was not very detailed as it related to each of the individual victims. So that's why I'm not rereading this on the live stream, because it's a lot of words that are similar to the words that was in the original indictment regarding the Cassie allegations, and it'll be a lot of repetitive stuff going on in there. So all you need to know is 3 new victims made at least two of them engage in sexual conduct that they didn't want to. And also there's another victim who was allegedly hung over the balcony. And I'm not saying he hung him with like a noose or anything like that, but just kind of like, pushed him over the railings, like basically, I'll drop you if you don't do what I want to say. They're still accusing him of using his fame in order to get them to comply with what he wants, using his money to get them to comply with what he wants, and also still drugging them to get them to comply with what he wants. And they did introduce two new forms of drugs. One of it was meth, was one of the other drugs they introduced. I think previously they had already introduced the baby oil, right? And which people believe that the baby oil has drugs in it. And they also introduced, I believe, cocaine, if I'm not mistaken, but I'm trying to bring up the document, so I am making sure that I am telling y'all the right stuff that was added into this one. So same allegations: force, threats of force, coercion, causing the victims to engage in sexual activity when they didn't want to, dangling one of the victims over the balcony. We already talked about that. And I'm trying to find, okay, it was psilocin. I don't know what that is, but apparently that's some kind of drug that they're adding into the claims regarding the racketeering activity. So his business, Bad Boys Entertainment, he had a bunch of people helping him get these kind of drugs and distributing these drugs to these ladies or these victims, because some of them were men. So psilocin, I think is what it's called. And then methamphetamine is another drug that is being introduced into this complaint. Now, it's the same long as the Cassie one. And it alleges pretty much the same things, but it adds in those things. And Diddy didn't fully respond to it yet. He hasn't been arraigned on this new indictment. The new indictment just came out on January 30th, but his lawyer did respond to the allegations against him. And I don't think it was the best idea for his attorney to respond, because he's basically alleging the same thing that he alleged with the Cassie. It was my girlfriend. They're trying to make it seem like I was doing bad things to my girlfriend. Yeah, you still can't force your girlfriend into sexual activities that they don't want to do. So his attorney is saying that the state's narrative is false and flawed, and that two out of the three new alleged victims were actually Diddy's girlfriend. As if that makes any of what he's being accused of doing okay. It's absolutely ridiculous. But that is all that I have on the superseding indictment. We're going to get into some of the other mess that has been going on since the last time we covered this case in November. Y'all know we are live. If y'all have comments, go ahead and drop it in the chat, because we're going to get to that at the end of all the information presenting, so that we can see your thoughts on the case. Let's go ahead and jump into the next part of what we want to cover today. So, like I said, a lot of things going on. We already covered the superseding indictment. Diddy is filing motions left and right. He wants to suppress evidence. He wants to look more into what the prosecution is doing. Want them to give some more of their information. And y'all, like I said, it's a lot. So I got to check my notes today. To make sure I'm covering the topics that I want to cover in the order that I want to cover it. And that is I was on the right track. So not only are they asking to suppress the evidence that was allegedly recovered in the sweep that they did back in the end of October, where he's saying that they got his attorney-client privilege notes. We're going to get to that in just a moment. But he is also asking to basically change the protective order and asking for more information or more access to things that, to discovery, right? So the court has already granted Diddy's motion to have his discovery laptop, where he can only access the information that is relevant to the case. They already granted that back in December. He can have it from like 8 o'clock in the morning to like 3:30 p.m. And he is able to access the discovery. They're wanting the laptop to do like other things, like take notes and things of that nature. Those programs are not on the computer. And the court basically said, if you want those things, you need to talk to the state and try to work it out together. Y'all really need to stop coming to me and complaining is the point that the judge is at. Stop coming and complaining. Try to work it out between yourselves first. And then you guys can come and ask for help if you are unable to basically get any agreement going. So I don't know if y'all have been paying attention to this case on other channels, but in December and I guess early January, there was some news going around about Diddy basically leaking photos from the sex videos of basically him saying that the sex videos that the state is using with Cassie's case proves his innocent and that Cassie was a willing participant. And so he files this motion to basically describe what is happening in the video that proves his innocent. And y'all, I'm hoping I got the right letter because I was rushing trying to get all these documents. Like I said, they've added about 70 documents since the last time we covered this case. So I might have some of the wrong stuff. So y'all bear with me in making sure we're covering the right thing. So I actually need to share the screen. That would be helpful, Bree, so that the people can see what I'm actually talking about. So boom, 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 share the screen. Boom. There we go. Now add it to the screen. There we go. So we have a letter from Diddy's attorney. Basically saying, my client's innocent. And here's why my client is innocent. The state is going to file a response to this letter indicating that it was inappropriate and needed to be redacted. So you're going to see some things redacted. So we're not going to get the full information about what is actually in these videos. We're going to get bits and pieces because some of the stuff is redacted because of the protective order. And Diddy's like, no, we need to change the protective order so I can have more access to this stuff and I can put this stuff out there. And although they're filing it in the court, Diddy wanted this protective order as to not litigate this case in the media, but it seems like most of his filings are to litigate the case in the media because they know that the media is going and downloading these documents just like we're doing today. So again, let's jump into this letter of Diddy proclaiming his innocence based on some of the discovery he has already reviewed. So this is his attorney saying, I write on behalf of our client, Sean Combs, to request a modification of the terms of the protective order to require the government to electronically produce videos described in paragraph 12A and 12C of the indictment. The protective order includes a novel provision making this video evidence available for inspection only and not electronically produced. Having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. The Rule 16 expressly requires production of copies of such materials to the defense, and there is no plausible good cause to restrict access to them under Rule 16d1. Accordingly, they should be produced in the normal course so that the defense may evaluate and use them in the same manner as the other Rule 16 and Brady materials. So again, they are asking for these sex videos. I hope I'm not going to get flagged on YouTube because I didn't said that word so many times and we're only within the first 15 minutes of the live stream. They're wanting these videos so that they can manipulate them. The prosecution has produced these documents these videos to them for them to view. And they want to be able to have those videos in their possession, i.e., in my opinion, get it leaked so that we can litigate this case in the media. Okay. That's my opinion of what's going on here. Y'all let me know what y'all thoughts are. The 9 videos at issues are so-called freak off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own homes, they sometimes filmed their sexual activities. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented, but thoroughly enjoyed herself. Like, you are absolutely out of line for putting that into a court document. And again, I feel like this is litigating it in the media because you know that we're going to go and pull these documents and read these things. You know we are. These recordings corroborate what witnesses have told the government, namely victim 1. The recordings also directly refute the allegations that Mr. Combs kept these videos as collateral. These recordings were not on Mr. Combs' devices and were not seized from his homes. Rather, victim 1 kept these videos on her own device for years and produced them to the government herself. And then, moreover, contrary to an innumerable sensationalistic media report, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much as a hint of coercion or violence. Far from the government's lurid description, the video shows adults having consensual sex. Plain and simple, at the bottom, this case is about whether victim one was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. And remember, like I said earlier, they're alleging that there are two more victims in the superseding indictment, and his attorney is going with the same narrative. Those were Diddy's girlfriends, and they consented to these sexual activities. That's going to be their position, is that he had consent, and he's going to try to prove it through the videos that the prosecution is planning on using. Background. Soon after Mr. Combs was charged, the parties began negotiating the terms of the protective order. During those negotiations, the government insisted over defense objection that certain videos obtained from victim one and depicting alleged freak-offs would not be electronically produced and would instead only be made available in-person viewing while monitored by law enforcement. The government explained that victim one, whose attorney gave those videos to the government, requested that they not be produced to protect her privacy, and that the government would honor that request. To ensure we would receive discovery without further delay, the defense agreed to receive the discovery under those conditions while reserving the right in the proposed order later to seek modifications of designations from the court. On October 7, 2024, the court so ordered the proposed protective order. So they agreed to something very well knowing that they were going to ask to change it later on. So I can see why they are making them only view these videos of Cassie while monitored by law enforcement, because we are touting the line. I mean, this is a criminal case. We're touting the line of revenge porn. So if we give it to Diddy and somehow it gets leaked, although Diddy is the one accusing the government of leaking everything, but if Diddy gets a hold of this and these videos get leaked, or the people within Diddy's attorney's office leak it or take a screenshot of it or do whatever they do with it, that can lead to very damaging consequences for Cassie, right? So I see why they are limiting the viewing only to be monitored by the police. Y'all let me know if y'all think that's right or y'all think it's wrong. Let's go ahead and jump further into it. After spending 4 weeks attempting to schedule viewing of the evidence, the defense was finally able to watch the videos under the supervision of law enforcement on November 20th, 2024 and December 30, 2024. The evidence consists of 9 videos depicting 6 unambiguously consensual sexual encounters. Let's see what the footnote says. It says number 2 footnote. They don't show us number 3. The government also included for in-person inspection certain explicit photos of victim 1 sent to Mr. Combs. The government redacted these photographs from the copies of the communication between victim 1 and Mr. Combs that were produced in discovery, even though such photographs do not fall within the scope of footnote 3 of the protective order. These photographs also appear to reflect entirely consensual sexual activity. I don't know how you get consensual from a photo, but they are saying that it's consensual. In all 6 of these encounters, victim 1 is not only consenting, she is evidently happy, dominant, and completely in control. Now, y'all, we are not seeing these videos unless you actually go to court, because this case is not being live streamed, but they're saying she's happy. But if we're coming from a guy that is forcing someone, how do we know if she is happy? I think that's going to be something she's going to have to testify to, as whether he would, if I didn't do these things, he would do this to me, right? If I didn't act like I enjoyed it, he would do this to me, right? Because one thing about abusers is they don't want to look like abusers. So if they're going to make evidence of what they're doing to someone, they're going to make sure you are fitting the part that they need. Some people don't want it to be a forced situation. They want it to be forced, but you're enjoying the force. So that, to me, Diddy claiming that she looked happy, his attorney claiming that she looked happy. How do you know she was happy? I think that's going to come from testimony of what was going on there and what was expected of her. There is no evidence of any violence, coercion, threats, or manipulation whatsoever. There is no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption. There is certainly no evidence of sex trafficking. Under Rule 16 requires electronic production of the videos, and there is no good cause to withhold the production. Rule 16, they basically say that unless there's good cause, the court authority to enter or modify a protective order stems from Rule 16D, which provides that at any time the court may, for good cause, deny, restrict, or defer discovery or inspection or grant other appropriate relief if there's good cause and they need to get to those documents, right? A party can demonstrate good cause for the issuance of a protective order when a party shows that disclosure will result in a clearly defined, specific, and serious injury, such as compromising the privacy interests of innocent third parties, causing a risk of harm to law enforcement or others, or impeding ongoing government investigation. The government cannot meet its burden. There is no good cause to prevent the electronic production of these highly exculpatory videos. Because this case does not involve classified information or child porn, there is no authority to restrict defense counsel's possession, review, and analysis of the videos. They had an age restriction case that they cited. Nothing in the Crime Victims' Rights Act provides similar discovery restrictions on an exception to Rule 16. I mean, we do have a celebrity that is, in my opinion, trying to do this battle in freaking the media. So I think I'm with the court in not allowing this. Or, I mean, they agreed to this protective order, right? They agreed to it. They're able to view it. There's going to be some other stuff we're talking about, and we'll see what the court does with it. Y'all let me know what y'all think that the court should do with this. Should they hand these videos over to Diddy and his team? Should they give them this video? They're claiming this girl is happy when she has produced it to the government to show that she was being abused. So his description of saying, oh, no, she's happy, this video is fine. Should the court believe Diddy on that? I don't know. Y'all let me know. Moreover, any concerns regarding victim one's privacy interests are adequately protected by the remaining provisions of the protective order. There is no greater risk in granting defense counsel a copy of the files for the preparation of its defense under suitable protective order than exists in the government maintenance and use of the files in preparation of its own case. I forgot to mention also, defense is basically saying it took them 4 weeks to be able to view these videos because they're having to coordinate with the police and they're coordinating with their own lawyers and all the things. That's what I'm assuming. They don't really say what caused it to take 4 weeks. Was the attorney on vacation? Was the prosecution given the runaround? Was the police department not available? They could have fully been the cause of their delay. And I say that because I have had multiple attorneys who have caused their own delays and then they tried to blame it on everything else but themselves. So give us a little bit information about what is causing these delays. So that sentence that I just read there was a case they cited granting the defense motion for copies of the alleged child porn in case that predated enactment of the Walsh Act. The government is free to designate the material as attorney possession only, which would require that the material be maintained in a safe and secure manner by defense counsel, shall not be possessed by the defendant except in the presence of defendant's counsel, and shall not be disclosed in any form except pursuant to the terms of the protective order. Indeed, the APO designation is for the precise purpose of addressing potential risks to the privacy and safety of victims or witnesses and sufficiently mitigates any risk of disclosure. That's a big task to put on an attorney, though, to make sure no one in their office leaks this. We're talking about a celebrity case, right? Even if there were some remaining privacy concerns, any hypothetical risk that the videos would be disclosed in contravention of the court's protective order is substantially outweighed by the real and substantial risk that Mr. Combs' defense will be hampered by limited access to the videos. Unless the protective order is modified to require the government to produce copies of the videos, the defense will not be able to effectively make use of the critical evidence at trial. The video include audio recording, but much of it is inaudible on the device provided for inspection, and what is barely audible requires headphones to hear. On certain videos, the lighting is also very bad, and the images are quite dark and grainy. Mr. Combs needs to use the defense experts, including inter alia experts, who could enhance the quality of the audio and video and analyze the metadata associated with the videos, including when the videos were created or modified. The government has offered to use a neutral expert to enhance the audio and visual quality of the videos. This novel proposal is inconsistent with Rule 16 and due process, as it would restrict Mr. Combs from retaining and directing experts of his choosing and require him to unfairly preview his defense. It also does not account for other ways Mr. Combs seeks to put the evidence to use. For example, Mr. Combs may need to show the recording to other experts or witnesses consistent with the terms of the protective order. Mr. Combs also needs to extract portions of the videos to create trial exhibits, stills, and transcripts. All of these tasks will be impossible without obtaining copies of the videos of the evidence. In sum, there is a much greater likelihood that defendant would be harmed in his ability to prepare his defense by limited access to the materials on the government's term than there is that the material will be further distributed by the defense in contravention of the court order. Mr. Combs is entitled to put the evidence to use for trial. So his attorney is basically like, trust us, we're not going to disperse these videos. Do we believe him though? Like, let's be honest, do we believe him? I don't know. Should the court give the defense the same benefit of the doubt that they've been given the state? They have been given the state a lot of benefit of doubt, okay? Videos constitutes exculpatory Brady material, and the restrictions on Mr. Combs' ability to use them in his trial preparation violate his due process. Brady also requires the government to produce copies of the videos. Under Brady, the government has a constitutional duty to disclose favorable evidence to the accused where such evidence is material either to guilt or punishment. They have disclosed it. They showed it to you. That is disclosure. It requires production of information such that a defendant can take advantage of exculpatory evidence in time for its effective use at trial. Let's see. An item is material to preparing the defense under Rule 16 if it could be used to counter government's case or bolster the defense. It is troubling that the government has had this evidence since December 2023 and nonetheless brought these charges. The video evidence refused to claim that victim 1 was forced to participate and can only be squared with her account of if one assumes, as the government apparently does, that certain women cannot consent, despite all indications to the contrary. They cite a bail appeal hearing arguing that when women are motivated by the loss of their livelihood and housing or experience abuse outside of freak-offs, they cannot consent, and that is sex trafficking. Oh, they're citing his own bail hearing on that. I was like, wait, there's other freak-offs? The government view also depends on the characterization of freak-offs as dirty, disgusting, and inherently unsavory, and therefore must have involved some amount of coercion. They cite the indictment describing freak-offs as an elaborate and produced sex performance and were arranged, directed, and sometimes lasted multiple days. They also refer to various freak-off supplies, including baby oil and lubricant. The premise that freak-offs are inherently dangerous shows that the government seeks to police non-conforming sexual activity and that it assumes, despite all evidence to the contrary, that a woman's willing participation must have been coerced. I think that's going to have to come out of her testimony. It's like the way that his attorney writes these documents is like, we're right, the government's wrong. They're wrong. They're wrong. Have you ever thought that maybe in Cassie's interview with the government, she said she was coerced and she was forced to put on some kind of act? She's a performer, right? She could have been putting on an act, but it's like the defense doesn't even consider that. Any fair-minded viewer of videos will quickly conclude that the prosecution of Mr. Combs is both sexist and puritanical. It is sexist because the government's theory perpetuates stereotypes of female victimhood and lack agency. The prosecution reflects the paternalistic view that the government is here to protect women who cannot be trusted to make their own decisions about sex and are not capable of consenting to sex that the prosecutors view as outside the norm. They're basically trying to be feminists and get us on their side, guys. These videos depict clearly consensual sex among willing adults in a decades-long relationship and fundamentally undermine the government's case and victim one's claims. Indeed, they are entirely consistent with, they have to black it out. They are unquestionably Brady material, notwithstanding the government's outlandish theories, and we anticipate that undisclosed audio portions and metadata will contain Brady material as well. At a minimum, they are certainly not ultra-sensitive material and need to be subject to extreme restrictions outside the normal use or the normal course of discovery in criminal cases. I'm like, I feel like he's almost getting off by trying to get these documents or trying to get these videos. And my thing is, if Cassie is lying, let's just give Diddy the benefit of the doubt. If Cassie is lying about this abuse, right? And honestly, there are certain allegations to specific events that they are referring to. So these other videos, you could say, for all we know, these videos are like, okay, these are like before it got bad, right? This is when I felt uncomfortable, but it started progressively getting worse. That could be what the videos are for all we know. But to try to convince the court that Diddy is innocent of any wrongdoing to Cassie, yet he settled a case within 24 hours for millions of dollars. And you want us to believe that she was not forced to do any of those acts? I don't know. I am not convinced. I am not convinced that you could say she was happy. If she was happy, you wouldn't have gave her $30 million in 24 hours, allegedly. You would have made her fight a little bit more in civil court, right? If that was the case. That's my opinion. That's my opinion. You wouldn't have gave her all that money if you didn't do nothing bad to her. That's my opinion. What would be the reason? Because you didn't give her the money before she filed the lawsuit. But when all the allegations came out, that's when you felt the need to give her the money. I think that's a problem for him. Although the court can't use that at this point, right? Finally, preventing Mr. Combs' defense team from obtaining copies of the videos so he can prepare his defense at trial would violate the due process clause and his right to present a meaningful defense. I don't want to go through all that. Because there is no good cause to restrict the defense counsel access to the videos, and because the videos must be disclosed pursuant to the Brady and Rule 16, we respectfully request the protective order to be modified to require the government to electronically produce the videos of Mr. Combs and victim 1 to Mr. Combs' counsel with the attorney's possession only designation under the protective order. I don't know. What do y'all think? Y'all let me know what y'all think. We're going to get into your thoughts and your comments once we go through the rest of the documents. And it's not too many more documents we're going to go through. So the state responds to this particular letter because when Diddy's attorney first put this letter into the file, they didn't redact any of that sensitive information that we saw, the blacked out letters. We can't see the unredacted form anymore because they fixed it on Pacer. So the state had to file a letter saying, hey, they're violating the protective order by detailing what is in these videos. Completely inappropriate. So let's see what the court had to say, the United States had to say about this letter that Diddy decided to file. Again, in my opinion, trying to litigate this thing in the media. So we got the U.S. government to the judge saying the government respectfully submits this letter to request that the court direct that the defendant's January 14, 2025 letter motion to amend the protective order be removed from the docket or refiled with appropriate redactions that comport with the requirements of the protective orders in this case. The motion seeks an amendment to the protective order related to certain videos that have been made available to counsel and the defendant for inspection only and not electronically produced videos. In making this motion with incomplete redactions, however, the defendant has violated the protective order he seeks to amend. The videos, which depict sexually explicit content and nudity, are designated attorney eyes only by the protective order, subject to carve out making the videos available for the defendant's inspection. All visual depictions of sexually explicit content or nudity will be designated attorney eyes only, regardless of whether it has been designated as such by the government. At the discretion of the government, certain AEO material depicting sexual explicit content and nudity may be made available for in-person inspection only. The protective order makes clear that the defense shall not share the AEO material or the content of the AEO material with any other person, subject to the carve-out allowing for the defendant's inspection of the videos. Further, AEO material is also designated sealed under the protective order, meaning that any portion of such material cannot be publicly filed on the dockets unless it is filed under seal, or the parties must confer regarding the sealed designation. Under the protective order, no portion of the video should have been filed on the public docket without being filed under seal or without the defense first conferring with the government as to the designation. Neither occurred. Instead of conferring in advance or redacting all content related to the videos, the motion blatantly violated the protective order when it left unredacted descriptions and characterizations of material designated as attorney eyes only. There is no alternative reading of the protective order other than the substance of the attorney eyes only material cannot be shared with any other person, and the EAO material is otherwise designated seal, meaning that it cannot be filed on the public docket. While the public designation of AEO material substantially impacts the privacy and safety of the victims, filing the AEO material under seal is in no way prejudices the defendant, as the full substance of the motion will still be before the court. The protective order thus serves to protect victims' interests and to prevent the defendant from, as he did here, selectively and improperly disclosing evidence to the public in advance of trial. So again, accusing Diddy of being the one to litigate this in public because he knows we are on the internet grabbing these documents. Let me tell them what I think is in the video. It comes off as the manipulation everyone is accusing him of doing. Let me explain to y'all what I see in the video. Screw what the government says. They're wrong. That's not what the video depicts. The video depicts a loving relationship. Do we believe Diddy? No. I don't. Do we? No, we don't. They go ahead and cite footnote 3 of the protective order, which is redacted in the publicly filed version, specifically addresses how the videos will be made available for inspection. The government therefore respectfully requests that the court remove the motion, the letter that we just read, y'all, from the ECF and direct counsel to refile the motion with redactions that comply with the protective order. With this motion, the government also submits under seal the court's review proposed redactions that comply with the protective order. After the motion was filed, the government immediately contacted defense counsel requesting that additional redactions be made in accordance with the protective order, and counsel responded only that they disagreed with the government's view of the protective order. Finally, the government respectfully requests that it be permitted to file its opposition to the motion within 2 weeks, that is by January 28th, 2025. The defendant takes no position on this request. I don't remember seeing the response. So we're not actually covering that today because I don't remember seeing the response. But I do know that the court denied the defense's motion to amend the protective order, meaning that they're not going to uplift the current protective order. But the court did hint that the defense would be able to edit it and access it outside of whatever the original protective order was. I don't know all the details on that, so I need to look into that a little bit more because I didn't even know that they filed a response by January 28th. So again, looking through a bunch of documents, I probably missed some stuff. So I'm going to go back and look at what was the court's reasoning in not changing the request for the protective order that Diddy is requesting. So he's losing again, right? He lost by there being a superseding indictment. He lost by not being able to amend the protective order. And then we're going to get into another loss of Diddy's. We're going to get into another one of his losses today. There has been a lot of losing on Diddy's end since the last time we covered this case in November. Did y'all know that? I didn't know he had been losing back to back to back. I didn't know that's what's been going on until I did my little catch up. But I'm going to look into the protective order stuff and what the court's reasoning was. In, like I said, they said the government is going to make it available for them to do their edits and put them together as exhibits. I don't know exactly what that entails, so I'll look into that and I will let y'all know. So let's jump into the last part of Diddy losing today that we are covering today, okay? I can't believe this. I can't believe this. Do I feel bad for him? No, I don't. No, I don't. Y'all let me know what y'all think in the comments. We're gonna get to it in just a moment. We got one more document that we're gonna go through. I'm probably only gonna read like half of this document because it kind of gets repetitive after a while. So let's go ahead and take a look into the second motion that has been pending with the court since about December of last year. So Diddy filed a motion to suppress evidence of the raid that the prison did back in October, at the end of October of 2024. He is accusing the state of collecting his attorney-client privilege, his notes and things that will prejudice him in the case. So he's asking that the government not be allowed to use any of that evidence that they obtained through the sweep of his cell. And there was a lot of motions going back and forth. I'm not going to lie to you. I didn't read all the motions. I did not read all the motions going back and forth because I knew that the court will give me the information that I needed in order to talk about this on the live stream. So I do have the opinion in the order of the court whether this evidence that Diddy is claiming that will prejudice him is going to be able to be used in court, right? Should they suppress this evidence? Now, I'm going to tell you, this live stream has been back-to-back losses. So y'all tell me what y'all think happened. Y'all tell me what y'all think happened. So this is an order coming from the judge in connection with the Bureau of Prisons, October 28, 2024 to November 1st, 2024, sweep of the Metropolitan Detention Center. A BOP investigator 1, photographed 19 pages of Combs' notes and sent them to the government's filter team. The filter team consists of ASUA, so attorneys for the United States, who aren't involved in the investigation or prosecution of this case. The filter team redacted the notes and sent them to the case team. The case team consists of the agents and the attorneys for the United States investigating and prosecuting Combs. In November, the government included some of what it received from the filter team. Sorry, y'all, let me do this. Okay. In November, the government included some of what it received from the filter team in its opposition to Combs' bail application. And Combs objected, arguing that those notes contained privileged information and were obtained in violation of Combs' constitutional rights. The court held an emergency hearing at which the government indicated that it would not rely on the notes in opposing the bail application. The court ordered the case team get rid of the notes in its possession, which it did. Combs has now filed a motion for an evidentiary hearing, other relief, arguing that the seizure of his notes violated the Fourth Amendment and the government intentionally obtained his privileged communication in violation of the Sixth Amendment. In response to the motion, the government argues that there were no violations, but also that it won't offer as evidence the notes or any fruits of the notes. In a December 2024 ex parte letter, the contents of which were later shared with the defense. The government outlined certain investigative steps taken upon receiving the notes, but it represented that it will not offer the evidence obtained pursuant to these investigative steps in the prosecution of the defense or of the defendant, and that it intends to produce the evidence obtained from these steps to the defendant to the extent it has not already been given to the defense. So essentially what happened here is that the government, they did a raid of the prisons, which they are known to do. The prosecution is saying we took the steps that were necessary in order to avoid coming in contact with any privileged information. If there are attorneys that have an invisible wall that do not work on the case, they are able to look at those documents and filter them and say, okay, well, this is not attorney-client privilege. Well, this is attorney-client privilege. And they're not supposed to be sharing that information with the attorneys that are on the actual team. And the court gives a lot of trust to these attorneys to make sure that they're not doing anything appropriate. And so the state's argument is, although we don't think we did anything wrong, we followed the protocol, we did not take any of the attorney-client privilege, we made sure it went through the proper filter team, all the things, we are still not going to use that information against the defendant. Now, I was not in the hearing, but it was already in the motions. It was already in the motion. So it's hard for me to believe that that was not actually used during the bail hearing. And the bail hearing is over. It's not like they're going to have another bail hearing because Diddy has withdrew his appeal for a bond. So them saying that they're not going to use it against him to prosecute him They already prosecuted his bail. So I'm a little bit confused. I'm a little bit confused about that. I could be, taking this in wrong. I could be, or I could not be. And this is just a stupid motion. I think it's just a stupid motion, but I could be wrong. I could really be wrong. Okay. So Combs' Fourth Amendment claim is moot. And I'm going to tell y'all right now, I think the court was really lazy in their opinion on this. Okay. So for a Combs' Fourth Amendment claim is moot. The first question is whether the investigator one violated Combs' Fourth Amendment right when he searched Combs' cell and photographed the notes. The usual remedy for a Fourth Amendment violation is to suppress evidence. Where are we at? Okay. Here, the government agrees not to offer the notes, any fruits of the notes, or any evidence derived from any investigation it undertook based on the notes in this case. Of course, if the government later tries to use evidence it has promised to exclude, then Combs can reprise his objection. But for the time being, the issue is moot. Okay. So, since the government pinky promised that they're not going to use it, the court's like, nah, we don't need to analyze it. We don't need to analyze it because they promised, they pinky swore that they're not going to use it. But if they do use it, you can just object at that point. Yep. I think that's really lazy. I think they still should have analyzed it so that if he does bring it up again, that it will already be resolved, right? Because if the government actually accidentally elicits testimony and puts evidence forward of the things that they found, we're going to have to go through a whole motion in the middle of the trial or in the middle of the hearing, whatever it is. Why not just analyze it right now? I was always taught in law school, it's like, even if you don't think someone has a case, you still have to analyze, but for sake of argument, he still doesn't win because of this. Give me reasons, multiple reasons of why he doesn't win, not just the government pinky promise that they wouldn't use it, so we're not going to talk about it. I didn't like that. I didn't like that at all. I'm sorry, y'all. I'm smacking the mic. I didn't like it. Okay, let's move on to the Sixth Amendment claim. No remedy is warranted on Combs' Sixth Amendment claim. Like I said, Diddy has been losing back to back to back to back to back. Okay. So they're saying no remedy is warranted for the Sixth Amendment claim. Relief may be warranted under the Sixth Amendment where the government intentionally seeks to obtain a defendant's privileged communication to interfere with the attorney-client relationship. There are two questions that matter here. Did the government intentionally invade Combs' relationship with his counsel? If so, has Combs been prejudiced? To make a violation of a Sixth Amendment rights, the defendant would need to establish the privileged information was passed to the government or the government intentionally invaded the attorney-client relationship and resulting in prejudice. Fifth, sorry, y'all. Under the circumstances here, assuming without concluding that a portion of the unredacted notes was privileged, there are no grounds for relief. The government did not intentionally invade Combs' privilege. There are numerous indications that the government did not intentionally invade Combs' privilege. First, it is undisputed that the photographed notepads were separate and apart from a manila folder that was clearly marked legal. Investigator one didn't search the folder, while Combs initially told the court that the photographed notepads were marked legal. As well, the defense retreated from this position when confusion developed over when the handwritten legal labels had been added to the notepads. You mean when defense counsel got up there and lied? When they added legal onto the documents after the pictures were already taken that didn't say legal on it? Don't try to smooth that over, court. Defense counsel lied and they had to back down on their position because they were in there lying. Don't try to smooth that over. Second, investigator one sent the photographs he took to the filter team, not the case team, to review for any privileged information. It may be that the filter team's privilege determination were inaccurate, but nothing indicates any intent to intrude on Combs' privilege. Third, the court notes that the high level and generic nature of the notes and the fact that the case-related commentary from Combs was often mixed in with clearly unprivileged information like reminders about family members' birthdays and inspirational mantras. Without the context later furnished by the defense had to explain how it was attorney-client privilege. The court didn't even see it. until the defense explained it in their own declaration, which explains how specific notes relate to the defense strategy. And given the circumstances in which Investigator 1 discovered the notepad separate from Combs' legal folder, there is no basis to infer an intentional intrusion into Combs' privilege. Finally, the government promptly turned the photographs over to Combs, which further weighs against any inference of intentional malfeasance. The episode illustrates why the filter team should communicate with the defense before giving Combs case-related material to the case team, but it does not bear the hallmarks of intentional intrusion or conduct that is manifestly, avowedly corrupt. So, the court is basically saying the filter team might have sucked, right? They might have not done their job, right? They might have been a little bit lazy, but that in itself is not corrupt. But what the filter team should have done is said, hey, we obtained these notes. This is what we marked off as attorney-client privilege. Do you agree? And they could have said, no, mark it all as attorney-client privilege. They would have been like, no, it doesn't work like that, buddy. Tell me what's attorney-client privilege. And they could have resolved it that way. The filter team should have communicated with the defense team, essentially, is what should have happened before it was used in the United States defense. Okay, so let's see. Combs further argues that even beyond the photograph note, Investigator 1 has been an agent of the case team, feeding jail communications to prosecutors and an informant in the defense camp. The court ordered both the case team and Investigator 1 to furnish sworn affidavits explaining the chain of events surrounding the MDC sweep and ordered the production of all written communication between the case team and Investigator 1 for an in-camera review. That's basically them just reviewing the documents with just the court. It's not in front of an audience because, as we know, court cases are public, right? So the public did not get to see these communications, but the court and other attorneys did. A careful review of these documents confirms there has been no intentional interference with Combs' attorney-client relationship. Affidavits by Christy Slavic and a prosecutor on the case team and Investigator 1 give consistent narratives. They blank it out because they say that the investigator's process is private law enforcement process that they don't want the public knowing about. So we don't get to see what they actually said happened. The case team then made requests for information about the communication through proper channels, including grand jury subpoenas. Two supervisors of the U.S. Attorney's Office were aware that the BOP planned to search the Combs unit during the security-motivated sweep, and they supported searching the unit despite delays in searching the unit. Slavic's affidavit indicates that there was no direction from the Southern District of New York personnel that Combs be under special scrutiny during the sweep of his unit, and no one at the U.S. Attorney's Office, including the case team, knew that Investigator 1 was part of the MDC sweep until after it was over. The case team was informed of Investigator 1's role following the sweep and promptly asked for the photographs notes to be sent to the filter team. Written communication between the case team and Investigator 1, which the court reviewed in camera, tell the same story. Far from an intentional, prosecution-driven invasion into Combs' relationship with his attorneys, the record shows that Investigator 1 was doing his job as a BOP intelligence analysis and followed the established channels for reporting communication that posed safety concerns. The case team was informed of these communications when appropriate and similarly followed the established channels of obtaining information and protecting Combs' privilege. Care was taken to shield Combs' communication with his attorneys from the case team. None of this suggests that Investigator 1 deliberately set out or was instructed to invade Combs' attorney-client relationship and impede on his defense. So, yes, they searched his cell, but it wasn't a plot, Diddy. Like, I feel like Diddy is throwing spaghetti at the wall and hoping anything stick. Like, that is where I am right now. I feel like he's just hoping that someone believes him at this point. Okay? Combs fails to show any prejudice, even if there was an intentional intrusion into Combs' attorney-client relationship, and there was not, says the court. A remedy is appropriate only if Combs is prejudiced by the intrusion. The question is whether the potential intrusion into Combs' privilege has produced directly or indirectly any of the evidence to be offered at trial. Let's see. As discussed above, the government has already stated it won't offer as evidence the notes, any fruits of the notes, or any evidence derived from the investigation it undertook based on the notes. The government also submitted an ex parte letter to the court explaining that the investigative steps it took, the results of which will not be used at trial, and it provided the defense with information in the letter. The court and the defense both now have the necessary information to flag suspect evidence if the government later attempts to use it against Combs at trial. However, at this point in the case, the wholly conjectural connection that Combs draws between privileged information and the government's case, including general allegations of taint unconnected to any specific evidence to be presented at trial, are insufficient for a finding of prejudice. So he basically said, nope, they violated my rights. They can't use the evidence, but he didn't really point out to any evidence that they're going to use that could potentially prejudice him. So the court is basically saying that he didn't meet his burden here. And then they go on to say that there's no hearing necessary, pretty much for the same reasons. There were sworn statements. The court required the investigator and the state attorney, one of the state attorneys, to detail the communication between them and how they got to that point. And it was sworn testimony, so there's no need to put them on the stand to ask them questions about what their thoughts were during the process, because it was spelled out in writing. They have the evidence that they need. And the court is basically saying that there's no need for any further hearing to see whether the evidence is tainted. The court basically concludes by saying that if this is to happen again, if they think that they're coming into some attorney-client privilege, it needs to go through the filter team first. The filter team needs to contact the defense, and then we can avoid all of this. This judge is really getting fed up with them and saying, y'all need to work this out together before you start filing motions. In my opinion, why are there 50 different documents in the case since December? It's more than 50, actually, more than 50, because I think we're at like 70 something, and now we're at 150 almost. So we got like 70 documents filed between orders and motions and letters and all of these things since December. The court wants them to work it out before they start bothering her. I believe the judge is a lady. But yes, so another loss for Diddy. And like I said, he's also withdrew his appeal on getting bail. I guess he's just accepting his fate and staying in jail. After the superseding indictment was served, he was like, I guess I better stay here because it's not going well for me. It's really not going well for me. So like I said, Diddy's losing back to back. Y'all let me know y'all thoughts. I'm about to jump into the chat to see what y'all think about what's going on with Diddy's case. If there's any information y'all want to know, let me know. I might know it, but I am just now catching back up on the case. So let's see what the chat has to say. We got Nissa Howard in here. We got another Maria in here. Hello, welcome in. We got Aloha in here. We got, oh, sorry. Why did I say Aloha? What's going on, Bree? Saying hi. Hey, hola from Vienna. Enos, hello, welcome in. Jazzy G saying hey with a waving hand. Hello, welcome in. Deacon Fatal, member and moderator of the channel. Welcome back, saying hello, all welcome in. We got Crystal Harris saying live in the hive. We are live in the hive. Deacon Fatal, and hello to Crystal. Deacon Fatal says, I will have to be a part of the rewatch crew because I am tired as all get out. That is no problem. Welcome in and also welcome back out because you need some rest. Deacon Fatal says drunk people cannot consent. And they're saying that they didn't look drunk. How do you look drunk? Like, what are you trying to tell me? Like, do you have experience with drugging people? Like, are you going to tell us that? Like, no, last time I made her too drunk, she looked like this. Like, how are we going to explain this to the court, right? Deacon Fatal says, I call BS. I agree. Deacon Fatal says were they drunk or high though? He's saying that they didn't look that way. But remember, this is Diddy telling us this. No, she looked happy. She didn't look drunk. She didn't look intoxicated. It's coming from Diddy. It's coming from Diddy, who people are also accusing of being too drunk and intoxicated all the time himself. Okay? Deacon Fatal says, I unfortunately have to head out because I'm tired. That's no problem. Thank you for stopping in and dropping some chats for us. Nissa Howard is also agreeing with Deacon Fatal. Deacon Fatal says, take care to all. Vienna Inna says, how many women on porn videos look like they're happy, but they're really not? So many women are coerced or even raped or R-worded, but put on put on a face for the camera. Diddy's lawyers are tripping. I agree. Like I said, she could have, like, to avoid being beat, you need to smile for the camera, right? That can completely be a situation that she's in. So to just say, oh, she looked happy, we're going to need her testimony like, yes, I was smiling, but if I don't smile, he will lock me in a closet for 3 days. Yeah, that's probably coercion, right? That is. Vienna NL says, expecting one party in the video of their sex to give up an amount of privacy is right there, an example of disrespecting her consent. It's not cool to expect access to that. And like I said, it feels like he's almost getting off by demanding these videos. I need these videos in my possession. So one, I can use it against you as collateral when I'm blackmailing you. That's what it comes off as. These are just my thoughts, y'all. Vienna NL says, wow, they're really reaching. I agree. ME says, the fact that Puff Daddy's bad boy even leaked a woman's video shows how disrespectful he really is to them on basic levels. That's what I'm saying. If these videos end up in Diddy's possession, we gonna see them videos. They're gonna be leaked. They're going to be leaked for sure. Vienna NL says, exactly. Vienna NL says, I don't want to hear it. I was snuck and beat up by a strange man on a bus and wasn't even allowed to see the footage at all before court. They get to at least see it before preparing the defense. Why? Yeah, well, that is good information. Not good that happened to you. I'm sorry that happened to you. But yeah, you don't always get to see the videos. You don't always get to have it in your possession. And the fact that the problem is that you were recording people and then using it as collateral against them. Yeah, we're not giving anything to you or your lawyers who seem to just believe anything that you say. Oh no, those were my girlfriends. That's how we played around. No, doesn't work like that. ME says deaf victim should see everything. The victim did have access to it, but Diddy is asking for access to it to basically like manipulate it and all the things. I need to look into it further as to what access the state is going to allow them in order to get the proper evidence that they need. Nessa Howard says he beat the crap out of Cassie. He did. And he paid her $30 million, but he wants us to believe that he was not abusing her, allegedly, right? Vienna, says some parties do file so many frivolous. I'm just gonna go with, I can't say that word. I don't know why. Frivolous, I'm gonna say motions to overwhelm the case and try to get the other party to show up, spend more time, energy, and resource so they give up. I was thinking that earlier. I was like, he's filing all these motions, and some of these motions has already been denied before, and then he's asking for them again and again and again. And it's almost like he's focusing on things that don't matter. He keeps saying that he doesn't have enough time to review the discovery, but you're too busy filing all these motions about all this other stuff that doesn't really matter. So I agree. I do feel like it's one trying to litigate the case in the media, as we saw with 50 Cent, Jay-Z constantly filing motions in the case that he is accused of in Diddy, constantly filing motions. Dude, you're not even served yet. Like, calm down. You're trying to clear your name through filing motions in a court case. You can't do that. Focus on the case. If you really didn't do it, prove your case. That's it. That's all you got to do. That is it. Okay, y'all. That's all I got on the updates on Diddy's case. We are all caught up. The order regarding the suppressing the evidence, that's the last document that we have access to in the file. So we got a couple of motions that Diddy lost on, that he filed himself, pissing the court off. Vienna, says, trying to distract the court. They're pissing the court off, constantly filing stuff. I don't think it's going to go well for you. Focus on the case, get it done, okay? And prove your case. If you're innocent, you're innocent. You don't need to file all these other random motions. I need the videos in my possession. Maybe that one was worth it, right? To see what the court would say. But you agreed to it. You didn't even have to agree to the protective order. You could have went to trial, or you could have went to a hearing on the protective order and let the court rule on it, but you didn't. You agreed to it. It's definitely harder to get orders overturned that you guys had a meeting of the minds and you came to an agreement on. Those are harder to get overturned than if someone just ruled against you. You can't really appeal agreements. You agreed to this protective order. That's hard. But I will keep an eye out on the updates on this case. I will look into a little bit more of what the reasoning was and what kind of access Diddy is going to have in order to prepare his evidence for the trial. Don't know how this is going forward with the trial date on May 5th. I believe he's going to be arraigned at a settlement conference in March. And I don't think they would be able to prepare for both cases by May 5th. So I'm very interested to see if and when, or I'm going to say when this gets pushed out, how far is going to get kicked down the line, because now we have this superseding indictment. I am going to have the weekend off. I hope everyone enjoys their Valentine weekend. If you celebrate that, hope everyone enjoys President's Day. If you have that day off, even if you don't have that day off, I hope that you enjoy that day. I think that's also saying, no, I was about to say St. Patrick's Day. No, it's not. No, it's not. That's in March. So never mind about that. But enjoy your President's Day. We will be back live streaming next week. Probably next Tuesday, we'll be back with some type of content. I don't know what we're going to cover yet, but hope to see you there. If you are watching to the end and you have not hit the like button yet, please do. It does help the channel out so much. And if you're not subscribed and you like what you saw today, make sure that you are subscribing to the channel. I will see y'all all on the next live stream. Bye.